Today we're talking about misdemeanor assault in Arizona. There are several different ways that you can be charged with assault and have it classified as a misdemeanor, and we're going to talk about it. Normally in these whiteboard videos I will have the statute detailed out. We're not going to do that today. Today, with the help of these two stick figures, one named Paul, who I may or may not know, and one named Robert. And what we're going to do is we're going to talk about how there may be an interaction between these two fictional individuals and how one may assault the other. So before we dive into it, let's remember, in Arizona, there are three different categories of misdemeanor offenses. You have three classifications: Class 1, Class 2, and Class 3. For a Class 1, that's going to be the most serious. That's at the very top. That's like DUIs, most domestic violence, and assault offenses are in that range. But you also have a Class 2, which is in the middle, and then you have a Class 3, which is the lowest. So let's remember that. There are different ways that you can assault somebody, and they fall within different categories. So let's look at the diagram, and I already have some lines here and some different ways that we're going to discuss how Paul might be able to assault Robert. And so let's start at the low end of the misdemeanor spectrum. So let's start with what could be considered a Class 3 misdemeanor version of assault. And I have that right here. So let's say that Paul and Robert are out in a bar, or they're out doing something together, or they're at home, or whatever it is they're doing. Paul decides that he wants to provoke Robert. And so we can see here for the Class 3, Paul takes his arm, takes his hand, and pokes Robert in the chest, which is totally unacceptable. But if Paul does that, that would meet the elements of the statute. So if Paul's poking Robert and basically trying to provoke him, trying to get a rise out of him, that would meet the elements of the assault for a Class 3. And so I have those here. Class 3, when you're touching somebody with the intent to provoke them or offend them, that could be a Class 3 version of assault, okay? Class 2. So Class 2 is a different type of an assault. There may or may not actually be any physical touching happening, but if Paul is doing that same thing, or he's in that same scenario, and he starts mouthing off to Robert, and he starts saying, you know, this about your mother, this about your sister, or whatever he tends to say in these types of situations, and the purpose of that is to place Robert in fear or in apprehension of some imminent physical contact. If Paul's saying, I'm going to beat you, I'm going to hit you, I'm going to do something like that, and it's reasonable for Robert to be in fear, if it's reasonable for him to be afraid of that or to be fearing for his physical safety, that can be a Class 2 assault. All right, and so the elements of that are placing another person in fear of imminent physical injury. And so if Paul's in that same type of a situation and he's making those types of statements, that could be a Class 2 level of assault. The most serious is a Class 1, okay? And that will happen when there is actual physical contact. So if Paul actually takes this right hook and makes contact with Robert's face and causes injury, which is quite frankly unlikely to happen because Paul is a weaker and more ineffective individual. But if, in some rare circumstance, that did actually cause injury to Robert, Paul could be charged with a Class 1 version of assault. So the elements of that are actually causing physical injury. As I said, it's very unlikely that Paul could ever do that to Robert, but in the event that that happened, Paul could be charged with a Class 1 assault. So those are really the three main ways that we see that happen, and they will range from a Class 3 all the way up to a Class 1, and the penalties, of course, are different depending upon what class of assault they are. So for a Class 3, the maximum penalty is 30 days, but for a Class 1, you could get up to 6 months in jail for that, and the fines increase dramatically as well. So let's say again that there was some sort of scenario where Paul was able to successfully assault Robert, and Paul does not want to be convicted of an assault. He does not want to have that on his record. Well, let's talk about the defenses. So how do we defend against these situations in court? Well, there's a couple of different ways. So the big number one way that we defend against these is we want to look at the availability of the witness. So let's say Paul is being charged with assault, and Robert, being his good, loyal friend, doesn't really want to have any involvement in it. Robert doesn't want to prosecute him. Robert doesn't want to go to court. Robert doesn't want to testify against him. Robert knows that Paul has a bit of a temper and sometimes, reacts outrageously at times. And so he just wants to ignore this and forget about it. Well, that comes down to the availability of a witness. Okay, so if Robert's not going to be there, Robert is technically the victim of Paul's assault upon him, and if Robert's not going to be there and be involved in the prosecution against him, there may not be anybody else who can testify to what happened. So Robert would not be there to testify that he was injured or that he felt that he was going to be an imminent physical injury or have imminent physical injury placed upon him, or he doesn't feel like there was any danger at all, or he can't substantiate that there was in fact some sort of a touching. If Robert's not going to be there in trial to testify about that, and there's no officers around, or there's no other third-party witnesses, or there's nobody else who can testify, then this case may not go anywhere, okay? Because there are certain rules about what people can say in court and what they can't say in court. So if Robert's not around, this case may be decided simply on the inavailability of a witness to testify against Paul. And so we see that happen a lot. A lot of these assaults are scuffles. The witnesses are not going to be testifying. We may not even know exactly who they are, or they may live out of state, or they may be a friend or a loved one or somebody who recognizes that this whole thing was just kind of a big misunderstanding and they don't want to be involved in it. So if that person's not there to testify and nobody else can independently establish that this assault actually occurred, the case might be dismissed on that or be negotiated down pretty significantly. The other way that we attack these, or we address what's called the mens rea. So what I talked about here is different ways that there's physical contact or there's some sort of action that took place, meaning there was a poke on the chest or a poke on the shoulder, there was some verbal language happening, or there was a physical right hook or some sort of contact that actually caused injury. Those are all acts. But those acts have to take place with the appropriate knowledge or with some sort of recklessness or with some sort of intent. So you have an act and then you have a mental state, and it's called mens rea in criminal law. So if this was a total accident, meaning there was no intention for this contact to occur, well, that may not meet the elements of the Class 3 assault. And so if you can show that Paul was not in fact actually acting recklessly, or Paul did not intend or knowingly do any of these things, maybe he bumped into him that caused the injury, or he was pushed by somebody else who caused the injury. If there was not that proper mental state to do that act, you can defeat the assault charge. Okay. The other thing that we also look into is what are called affirmative defenses. So if for some unforeseeable reason Robert was actually instigating this type of interaction between the two, and Paul was just defending himself, meaning Robert was the one who actually provoked the incident, Robert was making the threats against Paul, and then Robert started swinging at Paul, but then Paul was throwing punches back, that could be self-defense, and that's a defense that the defense, so Paul being charged, he has to raise that and he has to prove that, and there's a certain legal procedure that you have to go through to do that. But that could be a defense to Paul's assault. Okay? And a lot of the ways that we get these cases resolved is by negotiating it down, getting some sort of a deal with the prosecutor's office where the case will ultimately be reduced down to something that's non-criminal. Many jurisdictions offer what's called diversion, meaning if Paul takes some much-needed anger management classes or does something like community service to give back to the community, Robert may agree that this type of a case, this type of a situation warrants a dismissal. And so a lot of the time we can negotiate those out. When the defense gets involved, we have to raise these other elements or these other defenses and say, we're of course not going to be accepting a guilty plea to anything in this case. So if you want, Mr. Prosecutor, Mrs. Prosecutor, if you want to not lose the case entirely, we're happy to meet you in the middle and we can negotiate some sort of a resolution, presuming that it gets Paul's interests met, meaning Paul doesn't have a criminal conviction, Paul doesn't have to do something like an astronomical amount of community service hours or something like that. That may be a good outcome as well. So those are the defenses. So just a quick summary, these are kind of the three ways that you see assault happen. These are the common defenses. Now, I diagrammed it this way because, of course, it's a little bit easier to interpret and to convey how this works in this manner over video. But there are some jokes kind of interspersed through this video. But I don't want to mince words. Being charged with assault is a very serious offense, and it is something that can permanently stain your record. It is something that can follow you around for a very long time, impact your ability to find employment. impact, your professional licenses and those types of things. So it really is not a joking matter. If you have been charged with assault and you need some professional representation and you need a team of people who are going to help you fight back against the charge, give our office a call. We work with these all the time. We only do criminal defense law. We don't do anything else. And so we're happy to sit down with you, give you a free case evaluation, review some of your options, and make sure that you have a very strong plan in place to protect your record and protect your future. Thanks for watching.